much. Now, Honorable Finance Minister.
Mr. Deputy Chairman, sir, I am extremely grateful to a very large number of honourable members who've participated in this discussion, which was initiated by Mr. Kapil Sibal. Earlier, we've had a 17 to 18-hour discussion on the union budget itself. And a lot of issues which have been covered in the course of this discussion were referred to in the debate on the budget itself. And therefore, I will not repeat many of the points which have been stated therein. I had said at that stage that many of the claims which had been made about certain recent actions of the government were somewhat exaggerated in the analysis and comments of some of the honourable members of the opposition. The extent of disruption, the extent of adverse impact on the GDP, it now is increasingly becoming clear that some of these statements were highly exaggerated. Even during the course that the discussion initiated, and I will refer to various points of comment and criticism which have been made and repeated by a large number of members, were based on a particular analysis that Mr. Sibal gave. Just a minor sidelight of his speech, only to show the extent of exaggeration. He compared the present situation to the emergency. It's quite fashionable to do that, particularly by those who were otherwise supporters of the emergency. And then he made a claim, and I quote, इमरजेंसी में तो दो अहम बातें थी. पहली बात ये कि उस समय मीडिया चौकन्नी थी. उस समय मीडिया सरकार के खिलाफ जाती थी. यही बात सही थी, लेकिन आज मीडिया आपकी पॉकेट में है. So during the emergency, the extent of the exaggerated analysis is that media was very independent and very critical of the government. I think this is rewriting history at its worst. His second analysis was, which questioned the very basis, and he gave detailed statistics and figures and said, we have so many urban households, so many rural households, so many below poverty line, so many women who can't pay taxes. And therefore the net analysis was that India appears to be a tax compliant society. And therefore everybody in India who can pay taxes is probably paying taxes. And he said he's basing this on the 2011 census. Now this was music to at least my ears. I had in the budget speech mentioned that our direct tax base is a total number of people who paid filed returns is 3.7 crores. 99 lakhs out of that don't pay tax. They declare an income below 2.5 lakhs. 1.95 crores declare less than 5 lakhs, so pay marginal tax. And totally above 5 lakhs, you have 76 lakh people in different categories. The position of companies is also not very different. So you have 76 lakh people who pay taxes above 5, who declare an income above 5 lakhs. 2 crores out of whom take international travel every year. And we were told in this house, no, do it another analysis, India is a tax compliant society. So I am presuming now that the whole hypothesis has been built on the basis that everybody who transacts in property only pays by check. Everybody who undertakes luxury expenditure only pays by check. When elections are contested, entire political funding is only declared money. Because by and large, India is a highly compliant society. And the entire assessment and a critique of the various provisions of the finance bill is really based, because this is your erroneous hypothesis that everything is fine, and therefore it is no surprising that for 10 years you didn't take any significant steps in that direction. Yes, yes. And therefore, why do you want to take action which may either want to have an assault on what is the shadow economy or the parallel economy itself? Let us take this example of what everybody has commented on section 132. Section 132 in simple is a provision which has existed long time. All it says is that there must be a satisfaction note prepared which must give details before you can search or seize a property. So if there is a tax search, a satisfaction note must exist. You have done some basic homework. You have reasons to believe that somebody is suspected of having undeclared income. You have received some information from some informer. And there are reasons to believe which must be recorded in that note. This was always the law, this will continue to be the law. So nobody can enter a premises and start searching without that satisfaction note. And technically this satisfaction note gives to the tax authorities the source of information about tax evasion and the nature of that information. And that public interest demands that that source of information and the nature of information should be protected. If this is not protected, nobody is going to give information in future. It is in the nature of a whistleblower protection that the satisfaction note can't be made available to the target of investigation. Now, one of the court judgments seems to have indicated that the section as it is presently framed may require in the assessment proceedings, if the target of investigation says, give me a copy of the satisfaction note, you may have to provide it to him. Now the consequences obviously will be disastrous.
But it's only the reason.
Sources who give, after all, who are the ones who give information with regard to economic intelligence? It must be a trade union leader in the company. It may be a disgruntled accountant. It may be a dissatisfied partner.
You weakened the whistleblower
Now,
anyway.
historically, sir, under section 132, the satisfaction note is never made available to the person who's targeted. And there is good public interest reason for that. Now, one of the recent judgments seems to have indicated at the stage of assessment you may have to make this available. So the entire amendment is, if tomorrow a court asks us, Income Tax Department always gives it to the court. This is the reason why we search the man, if the court wants to be satisfied. It's not held back from the court. But in the tax appeal proceedings, nobody will ask for this note. This is not held back from courts. It's a protection as far as information with regard to offences is concerned. It's in the nature of that whistleblower protection, the nature of the information, and I am surprised that what is intended against an economic offender and to protect a whistleblower should be so made into a human rights issue. And the manner in which the argument has been addressed as though आप emergency लगा रहे हैं और एक उसको human rights दृष्टि से देख रहे हैं, जबकि वो केवल इकोनॉमिक ऑफेंडर के खिलाफ है और उस विसल ब्लोअर की प्रोटेक्शन के लिए है और उसने क्या इंफॉर्मेशन दी उसके लिए ये अमिट सोर्स है. दैट इज इंटायरली द नेचर.
So I want the finance minister's answer on record, because I know this debate won't end here. This will go to another forum. But I just want honorable members to please consider. The Income Tax Act is of 1961. It's now 56 years that Act has been in operation. It's nobody's case that no raids have taken place in the last 56 years. It's nobody's case that sources have not given information. It is nobody's case that reasons have not been recorded. And it cannot be the finance minister's case that in specific cases, those reasons have been challenged. And I'm sure the finance minister as a lawyer has on occasion challenged those reasons, and the courts have struck down those reasons. The commissioner can strike down the reasons. The appellate tribunal can say this action was illegal because the reasons were either illusory, non-existent, or unjustified. All that Mr. Sibal argued is the settled law is reasons must be given to the SSC, and the SSC must have the freedom to challenge it before an appropriate authority. Let the finance minister protect the source. In no case is the source given. I have dealt with this department, I've dealt with as a lawyer. No case is source given. It is only the reasons have to be given. If the reasons are bad, we have a right to challenge it. Let the finance minister say that all that he wants to protect is a source, but the reasons will be given to the SSC whenever he wants to challenge it.
My answer is very specific. The reasons will be given to the court and court alone. Otherwise, even the moment the satisfaction note.
No, listen. No, please listen.
And historically.
Please listen.
And historically.
Please listen. Sit down.
And historically, except to the court, the reasons have conventionally not been given to the SSC, because the reasons will make it clear as to what is the source and what is the nature of economic intelligence against him. If you are going to give the information which may lead to various conclusions with regard to the nature of economic intelligence against an assessee available to him, then certainly this is bound to be misused, and historically it has not been done, except when the court asks for it, it is given, it will still be given. And if the court says that the reasons are extraneous or the reasons are mala fide, the court is entitled to say that. That was the law, that will remain the law. Sir,
He feels.
First of all, sir, reasons to believe. These reasons to believe cannot be unreasonable. Number one, reasons to believe cannot be unreasonable, and if the court has the power to hear an aggrieved person on this point, then why the appellate tribunal shall not hear? Therefore, it appears from the statement of the Honorable Finance Minister that the government will not consider the demand made by the opposition parties who stage a walkout.
Okay, please.
sir,
Sir, the honorable Finance Minister has said. The Honorable Finance Minister has said that the reasons can be given to the court only. Now, which court is he referring to? Because under the Income Tax Act, after the appellate authority, IT-80, the matter goes to the High Court again under reference, and then goes to the Supreme Court also in the same manner. So it is not the 226 which is attracted. So if it can be given in a reference before the High Court after the IT-80, why can't it be given at the stage of the tribunal and the assessing officer and the... So which court is this reference to? Which court the Honorable Finance Minister is referring to?
No, please. Yeah, sit down. Okay. No, please sit down.
sir,
No, please.
sir. Let us now deal with what has been said with regard to cleaning the political funding in the finance bill. As regard political funding, historically we have seen a situation where we made several changes in the past, and those changes have produced only limited results. In the budget this year, by a primary amendment to the Income Tax Act, we have made a provision where political funding in 4 different manners is made permissible. The first is that anybody can donate money to a political party by check. Obviously, the donor will declare it in his accounts, the political party will declare it. And there is complete freedom on both the donor and the recipient to receive that money. This is a practice which is in vogue since the year 2001-2002. And obviously our experience has been that there has only been limited success in this area. And the reason for this limited success is that the donors have conventionally been reluctant, even when political parties have been willing to encourage it by check, for reason of disclosure of their identity and consequences that may fall on them. Even this was done when Mr. Vajpayee's government was in power. When the UPA government was in power, they created a mechanism of electoral trusts so that there could be some protection of identity of the donor. That itself also saw only limited success. It hasn't worked. Therefore, we have now, under the Income Tax Act, permitted a scheme under which you can donate by check, in which case your identities would be known. There will be a complete transparency and there will be complete clean money. You can donate small donations in cash up to a maximum of 2,000. This was the recommendation of the Election Commission. We have said that political parties could start online campaigns and get donations through the digital medium. which of course again would have the same tax exemption which political donations have. And the fourth is on these electoral trusts. Now, Mr. Sibbal's argument was that this is something which we have devised so that the ruling party stands to benefit out of this. The fact is much to the contrary. I had mentioned that our entire experience from 2001 to 2017 has been that while we have been all encouraging donors to give by check, it has made limited success. And therefore, in order to introduce clean money getting into politics, the whole institution of electoral bonds has been conceived. I have said that all political parties are welcome to give us suggestions. A particular bank would be notified by the Reserve Bank as the authorized bank which will issue these bonds. They can be purchased by any donor by check payment, so it will be clean money. Every recognized party will need one pre-declared account, details of which are available with the Election Commission. And the total donation that it gets through these bonds will obviously be known. So in the hands of the donor, there will be complete clean money. In the hands of the recipient, it will be clean money. There would be to some extent transparency, that we would know how much every party has received by bonds. The banks, within the limitation of their secrecy laws, would know who has purchased how much. How he has chosen his party will be something which is known to him. Now, this is a scheme which we have said that we are willing to frame under the Income Tax Act, and we have invited all political parties to make suggestions. In fact, the current arrangement inherently gives a greater advantage to a ruling party in the center of the stage. This arrangement would also have some advantage coming to those parties which are not in power, because the consequences of disclosure of identity, which the donors have been worried about, would not be visiting them in this arrangement. And therefore, this entire comment which is being made that this is being devised by you to help a ruling party, the truth is to the contrary. The ruling party has to be large-hearted to really frame a scheme under which people would be, without fear of consequences, willing to give it to somebody who is not in power. And therefore, my only appeal to my friends, particularly in the Congress party, has been, whenever such schemes have been framed in the past, they have been framed after a bipartisan consultation, so that major political parties can arrive at a consensus as how the scheme is to be worked out, that it can be worked out squarely. It's a first major step. Not too many steps have been taken in the past in order to cleanse the whole system of political money. And therefore, I would request them to kindly adopt a more positive approach and therefore make any suggestions with regard to the kind of scheme that they have any suggestions in this regard.
May I ask you one clarification? You see, the fundamental question is about transparency in political funding. That's what the Finance Minister is saying. But the larger issue of comprehensive electoral reforms, which were discussed in this House the other day, also touched upon the issue of funding, state funding, and creating a transparent process. Now, the electoral reforms cannot be limited that the contribution will come down to 2,000 and these bonds will be issued. Therefore, the government could have waited to bring about comprehensive electoral reforms, purely an electoral issue. Why are you bringing it in then the finance bill? You could have waited and brought about comprehensive reforms. So that's why the questions are being raised.
Anandji, 2001 it was done in the finance bill. And when the electoral trust was brought by your government, it was done through the finance bill. And therefore, there is not one, but there are two precedents in the past where electoral reforms in order to incentivize clean money into politics are schemes which are brought under the Finance Bill, under the Income Tax Act, and then corresponding changes to other acts are made. One of our objects also has been not to restrict the constituency of donors. For example, and I'll be candid about it, most sectors of the economy have been opened up to FDI. Now you have cases of, and I'm sure you are aware of it, of companies registered in India doing business in India exclusively, but because they have a foreign shareholding component, they were debarred from donating. As a result, we were restricting the constituency of donors. Now you know it better than me that if you restrict the constituency of donors, the temptation to go in for cash rather than official payment then increases. So as a matter of public policy, for clean funding, should we restrict the constituency of donors or should we expand the constituency of donors? And the idea is, and we are candid about it, so we made the corresponding amendments to the FCRA so that that restriction could be removed, and corresponding consequential changes under the scheme of the Income Tax Act have been brought in this time also, and the object is that the constituency of donors really should be expanded. Now, these are all schemes which in 2001 and 2010-11 were brought under the Finance Bill in order to cleanse political money. And I think as a national political party, at least the Congress party, should be one with us in our efforts, so should other parties be, to make sure how we can change the color and complexion of money that is getting into politics. Now, since let me just revert back to a question Mr. Chidambaram put to me as to why can't it be challenged, because in the past you said our experience has been you go to the ITAT and challenge the validity of the search. The decision to search is not and has never been an appealable order before the ITAT. It was only challenged before the High Courts. And before the High Courts, the government always produced the reasons. And the government has conventionally, before the assessing officer and the tribunals, not produced the satisfaction notes and never given it to the other side. Since there are some ambiguous court rulings, it's a clarificatory amendment to the effect that if you challenge it before the High Court, it will obviously be shown to the High Court. Irrespective of whichever proceeding the High Court says, it doesn't matter as to whether it's a reference or it's a writ. And therefore, this issue was never an appealable order before the tribunals. In effect, the status quo that existed since from 1961 till today will continue, so that this ambiguity which is created by which satisfaction notes would become available to the assessee, that ambiguity is being taken care of. Now, there are two other points which you made. And then you said you are expanding the network. Why should charitable organizations be surveyed under the Income Tax Act? Where a charitable organization gets a registration, gets an exemption to undertake charity. Isn't the Income Tax Department entitled to see that the resources of this organization are being used for the purpose for which exemption has been granted? Why should the Income Tax Department be debarred or the government be debarred from seeing that a charitable organization uses the charity only for the purposes of charity? Now, let me give you 2 or 3 illustrations, and I'm sure with his wide experience, Mr. Sibal would be aware.
I've been challenging this in courts of law, and you are aware what charities I'm talking about. They are your political opponents who you conduct surveys and who you search every other day, and we are fighting in courts from the beginning to the end. That's the charity you're attacking. Your own organizations which fund you, those are charities which you have never searched.
Sir, let us take illustrative cases. A charitable institution takes land from the government. A charitable institution builds a hospital on that land. A charitable institution gets an income tax exemption for running that hospital. The charitable institution gets a Custom Act exemption on all the equipment that it imports. And therefore, the entire valuation of the institution is based on the exemptions that it gets. Suddenly one day, the charitable hospital converts itself into a company, starts charging lakhs of rupees from every patient, and the corpus that it has developed on the strength of those charities and the exemption suddenly becomes its capital. Since Mr. Sibbal legitimately claims that he's been appearing in a number of cases, he knows all the cases that I'm referring to. Hasn't that
Who in the government, you also
hasn't
should
that-
know who in the government are targeting those people. You know that.
No, no.
You know that. The persons in the government who are targeting those people who are fighting for their very existence.
It's not a government. Irrespective of who's in government, the reality is that almost every hospital in Delhi who got land like this and created an institution like this is today a corporate hospital. So should the Income Tax Act says that because you were originally a charitable organization, I will shut my eyes because I have no power. And this entire money and corpus is...
You can assess the charitable trust has to file returns, and if they have transferred this, then you can easily assess them for all what they have done it. Where is the question of survey or raid?
Sir, if somebody, Rahman Khan Saab, is violating the law, let him be surveyed. Why should we sympathize with him? Somebody is allotted a land. Let us assume somebody is allotted a land for a religious purpose. He builds commercial buildings on it. Should the Income Tax Act say that I am not going to look at it? They are certainly entitled to survey this.
But the provision you have brought, we are objecting the existing provision gives ample powers to you. There is no, see, you yourself admitted the provision exists, 132, it is exists, it gives ample power. Why
Sir,
this? That is all we are asking.
Sir, something was made out of the fact that at the time of search there is a provision now for provisional attachment. Now at the time of search, conventionally you can take possession of the entire assets that you suspect to be illegally held. Now instead of confiscating everything, you can pass a prohibitory order of attachment saying, we are leaving it with you, but don't sell it in the meanwhile. Now, why should such a provision be considered unfair? When the assessment takes place, if it is a fair acquisition of wealth, it will be released. So all you are doing is that instead of confiscating it there and then and taking it away, you are provisionally attaching it by a prohibitory order, that's all. That don't sell it till the assessment proceedings are over. Sir, a lot of argument has been made with regard to the tribunals. Now, in each of these amendments to the corresponding acts, what is the position? Today, effectively, let us know the situation that under which we are living. We have different legislations under which either a regulator has been created, an appellate authority of the regulator has been created, or a tribunal has been created. Some of these appointments are made in the case of executive regulators, etc., by the government. And wherever judges, etc., are appointed, they are made in consultation with the Chief Justice of India. This is the provision almost in every act. Today, the harsh reality is that you have a number of these regulators and tribunals, many of which have inadequate work. You have 7 interstate river tribunals. 7. The average tenure of each one of them is to be calculated in decades, not in months and years. After one hearing, the next date will be fixed after 2 months. An office is created, staff is created, residences are given, salaries are given. What is wrong if the government says that let us have one river water tribunal?
Is that part of the amendment?
There will be one river water tribunal which will act on a continuous basis and all the river water disputes will go there. You are actually reducing government expenditure. You are making sure that the body has work. There are now regulators with some work which may be inadequate. And therefore, if 2 or 3 regulations can be done by one regulator, if the appellate work, you have the appellate authority of the ports, you have the appellate authority of the airports. Now, is there enough work to keep one institution, to create offices, to create residences, to create an entire permanent establishment? And therefore, who appoints? If these are judges, the law remains the same, the Parent Act remains the same, the appointments are made by the Chief Justice in consultation with them. The number has expanded to such an extent that in some tribunals, despite the best effort of even the successive Chief Justices, we are not able to get judges. Bodies are lying vacant because alternative modes of earning are far more attractive, arbitrations and so on. Public service is no longer an attractive mode. And therefore, I am in receipt of letters where I am told that I have asked all the eligible people, nobody is interested in joining. I have actually received this letter. Because in public service, you all make a sacrifice. In any form of private vocation, you can earn more. And therefore, people have made a choice. So if the government takes a policy decision by just one common amendment which says, the appointments will be made in consultation with Chief Justice if you are judges, the executive appointments will be made in that manner, we are not, Satishji, reducing the age. Because the age has to be actually kept now at 70 for a judge, so that we don't, the number of people available to us are not there. And therefore,
79 kV.
Therefore, all this hue and cry is,
when I read through the amendments in this regard, there was no provision saying that you will make these appointments in consultation with the Chief Justice. Please make that statement so that that's assured.
Please make that statement.
Make that statement that the chairman will be appointed.
if it is a judge, if it is judges, be rest assured this will retired judge also.
That it will be in consultation with the
It
Chief
will be in
Justice.
consultation with the Chief
Good,
Justice.
thank you.
The law minister is here. I think he reaffirms it. No, have no doubt on that.
All right, very good.
If it is, it will be provided in the rules
It's not
itself.
clear that the judicial appointments will be made in consultation with the judiciary. If
You see,
that
judicial appointments, Jairam, will be made in consultation with the
fine.
judiciary. I have no doubts on that. Now,
I understood. Some of the tribunals don't have adequate work.
the rules will provide for
No,
it.
please. Yeah. It's an assurance. It will be in the
Tribunals are
rules.
not having adequate work, so you are amalgamating them. And you have made certain things. But there are some tribunals who are overloaded, rather pendency is abnormal. PF Appellate Tribunal. You have merged it with the Tribunal under Industrial Disputes Act. Both are overloaded and both the tribunal, pendency of cases is to the tune of 10,000, like that. What is the argument of doing that?
All right.
Of the states, if you bring such cases to the notice, you can have additional benches created. The object is one related to governance. Today, to create a body which has very little work, is it not better from the point of view of governance to get the same body to administer 2 or 3 if there is inadequate work, so that housing has to be made available, offices have to be made available? It's a huge pressure as far as expenditure is concerned. No, please bring it to the notice. Wherever you have a problem, we'll certainly have it looked into.
You already said additional benches can be.
Sir, Mr. Sibal made a comment with regard to Aadhaar. As far as the legislation is concerned, that itself makes it clear in section 7. As far as benefits are concerned, the benefits, you can produce an Aadhaar card, and if you don't have one, you can produce any other proof of identity.
And apply for Aadhaar also.
And simultaneously apply for Aadhaar. Fortunately, the scheme is successful. Almost 98% of the adults have gone in for it. And I'm sure this will continue to improve. He was right on one count, and let me tell him, some of us at some stage had doubts. Immediately when this government was formed, the Honorable Prime Minister took a presentation, I was present. I put across those doubts, some of which had been raised even by your colleagues when you were in government. They were answered adequately, and we were candid enough to say, we accept that it was a great initiative and we will expand this initiative. We accepted that. I have no hesitation in this. But as far as tax evasion is concerned, the present bill says either give your Aadhaar number or give proof of the fact that you've applied for it. That's all in your tax assessment, so that the possibility of a person committing tax frauds, 5 different PAN cards, all that can be eliminated. Why should we at all not allow this technology, which was created in larger public interest, be utilized for this particular purpose? Sir, these are broadly some of the main points. As far as the taxation proposals are concerned, I may only say this. While encouraging more and more people to join the tax net, the lowest slab we have reduced to 5%. And the idea is that more people should feel attracted enough to join.
Mr. Vavil, he's moving on to another subject. We are grateful that you have acknowledged that Aadhaar was the initiative of the previous government and you have expanded it. The question is, one, the purpose of Aadhaar. Aadhaar was as an instrument to extend services and benefits, especially subsidies. Aadhaar was never intended to be tagged to income tax returns and bank accounts. But if your government has taken a decision to tag it to income tax accounts and bank accounts, so be it. I'll accept it for the time being that maybe there is some benefit by asking it to be tagged to income tax accounts and bank accounts. The larger question that is being raised, and I think you should answer, how will you protect the privacy of transactions in bank accounts? How will you protect the privacy of fax material in the income tax returns? The Pentagon has been hacked. 500 million accounts have been hacked by somebody sitting in some country of Europe. What is the guarantee that you have the technology to prevent hacking of bank accounts, hacking of income tax accounts through the Aadhaar number? Mahendra Singh Dhoni's wife has complained that his Aadhaar number has been made public. Now, if Aadhaar numbers are available to a large number of authorities, what is the guarantee that using the Aadhaar number route, these accounts will not be hacked and the privacy that is required to be maintained about these accounts will not be breached? That is the question.
I think the Pentagon got hacked even without the Aadhaar being there. So the hacking doesn't take place because of Aadhaar.
Sir, I appeal to the finance minister not to trivialize the question. I asked him a serious question and I request him to seriously answer. Let's not caricature my question. If you don't want to answer my question, say I don't want to answer. Don't caricature it, don't trivialize it.
It's a serious answer. If the firewalls can be broken and hacking can take place, then hacking will take place anywhere. That is not a ground that hacking takes place only because Aadhaar is there.
Okay, please. No, please. No.
In any
He is
case,
not yielding. He is not yielding. Sit down.
let us assume,
He is not yielding. Sit down. Bhattacharya, sit down. He is not
Mr.
yielding.
Chidambaram, let us assume
He is not yielding.
on a more,
I am not attributing motives to the government. I am asking how will you prevent it?
therefore, let us assume there is no Aadhaar, but some information which is contained in some network gets hacked or gets leaked. That is because of the technology you use there, and which technology itself can be broken into. And therefore, the fact that technologies can be broken into is never an argument which is given, so don't have technology. Therefore, the answer is that your firewalls that you build around such a structure must be strong enough. The Aadhaar legislation has some provisions with regard to this. But if we have the benefit of that technology, now don't compare it with what happened yesterday to Mr. Dhoni, because this was a case where some individual misconducted himself for the craze of a selfie or a photograph. And he's been blacklisted for 10 years. It was an immature behavior of the person who went there. But as far as the fact that therefore have a better technology, the idea therefore not to use technology or to go in only for obsolete method of collection of documents is not the answer.
Okay, that's all.
Sir, I really want to know from the Honorable Finance Minister, there have been a report of a particular college giving out the names and list of the students who won a scholarship with their Aadhaar numbers. Now, it may be completely, government may be unaware, I'm not saying government is involved in it. Now, what I am saying is, what is the protection? What is the protection? Does anybody making public an Aadhaar number of somebody else, is there any law to prevent? What is the protection?
In the Aadhaar legislation itself.
He can be prosecuted.
For making it public, he can be prosecuted. These are provisions in the Aadhaar legislation itself.
That's already there. That is already there. In spite of that, sir, all that I am asking, and I think that's what is the sentiment from there also. All that,
Therefore,
what is the protection?
Sir, let me...
What is the protection? What is the protection? Sir,
Okay, he's not yielding. No. He's not yielding. He's not yielding. Speaking of Aadhaar with the PAN number, what I want to ask the Honorable Leader of the House is, can you take us into confidence as what is your broad estimate of the fake or duplicate PAN numbers in the 17 crore universe that you are dealing with? Because this must have been at the back of your mind to introduce Aadhaar. In fact, Aadhaar was optional in 2012. You have made it compulsory. You have made it compulsory now. So I want to know how serious is the fake or duplicate PAN card problem, which has forced you into this. It's a straight factual question I'm asking.
Let me
That's
clarify.
okay. That's okay. Now that's enough.
Technology always is a learning experience. Now, if you recollect, when the UPA government brought the Aadhaar legislation, when the UPA government brought the Aadhaar legislation, the legislation itself only dealt with the manner in which the cards are going to be issued. The law was never finally passed, but that was the draft law. What do you do with that Aadhaar card? The legislation did not mention. Now, as we learn from the benefit of that technology and the strength of that technology, can it be used to make sure that benefits are not misused? Can we make it for direct benefit transfer? Can we use it for detecting any form of tax misrepresentation or frauds? Now, these are all areas where we are now expanding into. I share the concern, and that is why there is a provision in the Act that privacy norms must be maintained, it can't be made public. So if anybody on the list of successful candidates makes Aadhaar number public, then he is guilty of violation of that particular Act. But the fact that somebody in Ranchi or somewhere else has violated it, let us not discredit the technology as a whole itself. Sir, my final point.
Yeah, please, please. No, it's
My
okay,
final
please.
point, sir. We have reduced the first slab in order to make sure that there is an incentive for more people to join. We've tried to encourage the MSME sector. We've tried to encourage housing sector and certain other areas of investment. We are also trying to discourage cash transactions to the extent that is possible. Now, these are various provisions which we have brought in, and I would urge this Honorable House, therefore, to support these provisions as far as the finance bill is concerned. Thank you very much, sir. That's all I have.
Well, thank you very much. No, enough has been asked. No. What assurance?
2 questions, sir. Sir.
No. Yes. I allowed you to raise it. You raised it.
No, you said the finance minister can answer.
And see, it is up to the finance minister. No. Yes, I allowed you to raise it. Now, Kanimariji raised it. It is up to the finance minister to reply to that or not. I cannot. It's up to him. Yeah, please, let me. No, please. Raja, yes, you already raised it. Yeah. If all of you. Yes, what is your problem? Navneet, what is your problem?
We are not compelling.
What is your problem?
It is not, we know it is very difficult one. But we want to raise it in the presence of Honorable Prime
Yes,
Minister.
what do you want to, you say?
The difficulties.
What do you want to say? What is the problem?
Yes.
I already allowed you earlier.
Now the Tamil
Now what do you say
government
now?
wants the central government that
no.
loans provided by the banks.
I have allowed you to speak.
So it is my humble request, our finance minister.
Okay, what is Raja your problem?
Request of the Tamil Nadu farmers to waive the loan.
I have only
provided
You
by the
said it.
provided by the banks.
Sir,
Please consider kindly.
No.
I request the
Okay.
honorable
Sir,
finance minister.
No,
sir, Deputy
no,
Chairman,
please. No, the issue. See,
all the time you are shouting.
Navneet ji, बैठिए. Udkar होगा. No. Kanimari ji, you raised it, you said it, finance minister knows it. I need not ask him. If he wants, he will reply. Now, Raja, it's already raised. No need of raising again. Raja, it's already raised. No. After the reply, I have to put it to vote. No, please. What do you want?
2 questions. Number 1, the finance bill gives loan waiver to startups for 3 consecutive years. I am asking the finance minister, will he consider to give loan waiver to the farmers?
That is already raised here.
Number two,
That was already raised.
Number two, finance minister spoke about funding, political funding, cleansing.
He
the
replied
system.
it.
No, I am asking, I am not a lawyer like him. I am not lawyer like the former finance minister, Mr. Chidambaram.
You are bigger than lawyer.
I am a political activist.
no,
I am asking the finance minister. Corporate funding is the fountainhead of corruption.
Okay.
And
All right,
the
what is the
government
issue, Shiva?
consider banning the corporate
One is loan
funding.
waiver,
It
sir.
is-
Second is,
Loan waiver already asked.
when the finance minister says that the NDRF fund cannot be sanctioned without the advice of the high-level committee. Sir, I would request the finance minister within his jurisdiction lies that accelerated irrigation benefit program, AIBP, they can extend loan assistance to the state government, which the state governments are not able to implement the irrigation facilities, number one. And second is to immediately advise the insurance companies to disburse all the insurance
Okay.
amount. That I think when we
Okay,
met
now the
yesterday, you
question
told,
is that-
kindly please say, sir, that
Now
would be a
the
message
question
to
is
the
that-
agitating farmers.
Okay.
Please,
Now the question is that
you please tell us.
Now the question is that the finance bill